naelewa kile kinaendelea, na kwa hivyo naenda kukusomea mashtaka ambayo imeletwa kotini. Yes. Yes, please.
My lady, we have not been served with that
information.
Assessment.
The assessment.
However, I've managed to glance at it.
Print a copy for the advocate right away. Yes.
I've managed to glance at it, my lady, and we have a word or two to say on the same. Before, please take a report. It serves as a valuable tool that empowers the court to protect and safeguard the inherent dignity and the right of the accused person as guaranteed under Article 28 of the Constitution. Could not have been better put, my lady. My lady, the defense takes issue with the form that the mental assessment report is in. My lady, I refer us to the Court of Appeal decision in Motoni and another versus Republic 1982, where the Justice Potter held that where an expert witness hopes to carry weight in a court of law, before giving said expert opinion, one, they must establish by evidence that they are specially skilled in that science or art. My lady, I believe that would require some formal evidence of the credentials of the doctor that issued the report. Number two, and most importantly, Your Honor, sorry, my lady, is that they must instruct the court in the criteria of their science or art, so that the court may itself test the accuracy of their opinion and also form its own independent opinion by applying the criteria to the facts proved. In short, Your Honor, the conclusions must match the formula. The report before us, for lack of a better word, appears shallow, consists of check boxes, does not state how and when and for what period the accused person was examined by a qualified psychiatrist.
Let me stop you first. Is he normal? You are his advocate now because the doctor says he's normal. Is he normal or not?
The report is to establish that.
The report has established that he's fit to plead.
You're contesting.
You are contesting?
Yes.
Okay, you should just say that. No, sir, okay, proceed. Then you say that. I'm wondering what's going on. You are contesting that he is not fit.
No,
yes.
Contesting
that
the format.
The format of the report.
The report. You want a detail.
You want a
detailed
okay.
mental assessment report, like all other medical reports.
Okay.
A lady, it is common knowledge that mental evaluation is not a one-off affair. You do not go to the outpatient, are seen for 2 minutes, and are diagnosed. We expect or expected that the accused should be observed severally over a long period through lengthy sessions, and lengthy notes should be detailed and furnished to this court and to the defense and the prosecution, showing how the conclusions are arrived at. My lady, this case is not like most others, in the sense that the mental assessment report being carried out here is not merely perfunctory. It is not merely to check a box. There have been suggestions by experts in the field, by the officers under whose custody he has been, that he does not appear mentally fit or sound. My lady, every day in the streets I'm accosted by citizens telling me, why is this person being tried yet is unfit? It is apparent.
How did they know you? Those ones who are approaching you, are you telling everyone you are representing him?
No.
Because I go to the market and no one recognizes me and I sit here as a judge. Tell me how the people in the streets are identifying you with Kalombotole.
It must be the smile.
You are so funny, counsel. Continue.
Finally, the third criteria
Yes.
for the expert evidence is that the evidence that the expert should give evidence on the facts on which the facts may be ascertained by him or the facts are reported to him by another witness. My lady, we are simply asking for a thorough process. We do not want to rush, we do not wish to rush through this process. This is a very grave matter for both the victim, their family, the accused, and the public at large. My lady, the public has taken a keen interest in this matter. This is an opportunity to demonstrate how justice is served in this country. We must be deliberative and substantive. And therefore, we pray that we make orders to the effect that a proper mental health assessment be conducted on the accused before plea taking. My colleague will address you as well.
Okay. We have that was Mr. Who?
Obengi.
Mr. Obengi, yes. And I want both of you to tell me that your client is not fit. You, in your view, because you are the one who has interrogated him, because you are actually challenging a medical report.
Discussed extensively the issue of mental assessment. I wish to rely on several paragraphs. The first paragraph is paragraph 8, where the court made the statement. It is only through an examination that the presumption of sanity can be rebutted. My lady, I'm in paragraph 8. And it remains the sole method of establishing whether a suspect is of sound mind. My lady, I do not wish to reprint the whole authority. Also, paragraph 10, paragraph 11, paragraph 16, and paragraph 18. And it is straight to the point. This court has the authority to order for a second mental assessment report. This court pronounced itself and said in paragraph 16, any person who wishes to be examined by a doctor of their choice should be free to do so in order to challenge the report of a government psychiatrist. Finally, paragraph 18.
You stop there. You tell me that you want to have your own, you can't just read. His will, he should be ready to challenge. Are you now ready to have him subjected to your own doctor? That's where you should pause before you continue. Yes. Read that paragraph again. That the one you've just read. The one you've just read.
Any accused person.
Yes.
Who wishes to be examined by a doctor of their choice.
Exactly. Do you want that? Because that's all you needed to tell the court. Do you have a doctor of your choice? Yes. Does he have a doctor of his choice? So that we can just stop this and say it is okay. Can he be examined by a psychiatrist? Do you have a doctor of your choice?
The accused is and has been a ward of the state even before these proceedings. You had indicated to us the last time we were before you.
No, let him finish, then you'll make a rejoinder. We are going to confuse counsel. Have a seat, I'll give you time. Once he finishes, then you can respond. Flag that. Let the advocate continue. Proceed, flag it. I'll give you time to add. Yes.
Yes, my lady, given an opportunity,
yes,
the defense can organize.
Yes.
For a psychiatrist, an
yes.
independent psychiatrist to do a mental assessment. We can make arrangements.
Okay. Okay, now, Mr. Cheriotna, you are done? Are you done?
Yes.
Yes.
My lady, we have made extensive efforts to try to get assistance from medical professionals and organizations to assist us with carrying out such an assessment on the accused. However, my lady, it seems the Hippocratic Oath is not always binding, since no one has so far agreed to assist us with the same. This is why I was alluding to what you had, or rather this court had informed us the last time we were here, that Mathare exists as a referral institution. And if Magathi is unable to provide a satisfactory report, perhaps he could be referred there for proper, detailed analysis before we can proceed. That would be our prayer.
Can I hear what the state has to say?
May I go before the state? This is Dennis Minor.
Yes.
Thank you. Having heard the sentiments of as to why there is a challenge to that mental assessment report. So our position is that even as we maybe accommodate the accused person, we also need to have in mind the rights of the victim to, at the very least, have these matter comments, and on the basis of the report that has been availed before court. My lady, such a report can only be challenged with another expert report. And no such report is before you. We pray that, my lady, you direct that this matter at the very least commences by the accused taking plea.
Ms. Timoi?
Ms. Kishoi will address.
Ms. Gishoi, you're on the platform? Ms. Gishoi?
My lady, I'm present. Can you hear me?
Yes, very well.
Yes, my lady. We are concerned with the issues that are being raised at the moment. The mental assessment had been ordered by the court. The defense were well aware of it, and they had not brought any issues that they wanted a secondary or even their own psychiatrist to take part or have a subsequent report. My lady, the purpose of the mental assessment as ordered by the court was for plea taking. The mental assessment is before the court. It is authored by a doctor whose qualifications have not been challenged by the defense. It is adequate and it is specific in terms of what the doctor noticed. And my lady, the doctor has said he's fit to plead. My lady, I believe that the issues raised by the defense are not grounded. They have not specified any issues that have raised concern. They have just said that they are not satisfied with the format and they want a subsequent report. My lady, the first thing we should proceed to do in this matter is take plea, because the mental assessment before the court is specific. And then any other issues that are to be raised by the defense, including if they want a secondary assessment by their own doctor, can be canvassed. At the moment, they are not telling us if there's an issue with the accused person. They are just saying that they are not satisfied. But they have not laid any foundation to tell us why they are not satisfied, my lady. You had given them a chance to get their own doctor, but they have stated that they are not able to do that. The state has gone to a great expense to facilitate mental assessment. It is before the court. And we pray that we continue on to plea taking so that we can then proceed to taking hearing dates in this matter. But any allegations raised by the defense should be proved and should not be just mentions of the calf melody. Mr. Moy will continue on any other issue, Melody.
Yes, Mr. Cheriot.
Quick rebuttal. First, I disagree with almost all that my learned senior Mosquito has stated, because we have in fact challenged the substance of the report on the basis of the criteria set in Butoni versus Republic, where one, it has not been established by evidence the special skill of the maker of this report. We merely have a name and number, but we do not have evidence of the qualification. Secondly, by the same criteria, we do not have the criteria or the method of how these conclusions were arrived at. This assessment report does not conform to the law as stated by the Court of Appeal. Finally, my lady, in fact, if you take time to read the report, you'll find that there are numerous references to diabetes and convulsions, even including and especially a conclusion. The conclusion says nothing about his mental state. Is this a mental health assessment or a medical report from so that will be all.
It's a chapter. I think at this juncture, what we have put the accused person to plea, then later on after taking...
And that's why I've been asking you as a counsel. Do you have another doctor who you...
The issue that we have is that we need to understand how it's done. Even for us...
Let me
for,
have
for
a
us,
mind. Let me have...
For us to even challenge, even try and interrogate it. Because what we are seeing here is ticking of the boxes.
Okay.
There are no notes that accompany this particular findings or anything that informs this particular. There's nothing that actually shows that this person came to me and showed these particular traits. This particular person shows this particular trait, and that's why I'm inclined to say that his mood is happy. So I think we need not jump the gun, because the mental assessment is a critical element in a criminal trial. Therefore, it must be given the weight it deserves. And the court ought to move on a very cautious manner so as to not find itself to have overlooked certain issues or overlooked certain material facts. As you can read. So I can leave the floor to my colleague Joshua.
Joshua, you are on Bengi.
Yes, Malik. Finally, Malik. I have with me here a judgment from the Supreme Court on victim participation. I wish to rely on paragraph 78F. Guidelines on victim participation, paragraph 78E. Sorry, Malik. 78E. It reads, victim participation must not be prejudicial to or inconsistent